So Donald Trump has just had a total breakdown inside a federal courtroom after Judge Sara Chen ruthlessly blocked his attempt to delay a crucial criminal trial for the seventh time in 3 months. And what triggered this eruption was something extraordinary. Trump tried to use a last-minute maneuver to postpone the start of the trial on falsification of business records. But this time, the judge not only denied the request, she publicly destroyed it in a 47-page ruling that described his tactics as a flagrant abuse of the judicial system. As someone who has spent decades covering Washington and observing constitutional crises, I have rarely seen a judge use such forceful language against a former president. Judge Chen did not limit herself to rejecting Trump's arguments. She called them frivolous, malicious, and designed exclusively to sabotage due process of law. And Trump's reaction, according to reporters present in the room, was visceral. He turned visibly red, began gesturing aggressively toward his lawyers, and at one point was heard muttering obscenities loud enough for potential jurors in the hallway to hear. This is not simply another legal setback in the middle of the avalanche of Trump's legal problems. We are talking about the moment when a federal judge effectively said, "Enough, I am not going to tolerate your manipulations any longer." And believe me, in my years observing the U.S. judicial system, when a judge reaches that point of documented frustration, it means lines have been crossed that never should have been crossed. Trump's explosive reaction shows that he has finally found a judge who is not going to bow to his usual intimidating tactics. It is frankly hard to process that we are witnessing a former president losing control in a federal courtroom because a judge refused to allow him to postpone indefinitely his day of reckoning. But let me bring you up to speed on exactly how we reached this unprecedented point. The case in question involves allegations that Trump falsified financial records of the Trump Organization between 2015 and 2020. The indictment maintains that he systematically inflated asset values when seeking favorable loans from financial institutions, but then deflated those same assets when it came time to pay taxes. We are talking about massive discrepancies. His apartment in Trump Tower was valued at nearly 3 times its actual size. Mar-a-Lago was listed at more than $500 million when it was worth a fraction of that. These are not minor accounting errors. They are systematic distortions designed to deceive. The Manhattan District Attorney's Office has been building this case for more than 3 years, and the trial was scheduled to begin on January 15, 2026. According to the Politico report from December 18th, Trump has employed his classic strategy of delay, delay, delay until everyone gives up. He has filed endless motions on change of venue, claims of presidential immunity, requests to exclude evidence, and even argued that the proximity to the elections would make the trial politically damaging for him. Judge Chen had patiently denied each of these tactics, always with legally solid decisions that have withstood appeals. But this is where fundamental principles come into play. The last straw came when, 72 hours before the scheduled start of the trial, Trump's legal team filed what they called an emergency motion, claiming that one of the prosecutors had committed professional misconduct by giving an interview on a podcast where he discussed general aspects of the case. Now, let me be absolutely clear about something. In U.S. criminal law, prosecutors give interviews all the time, as long as they do not reveal confidential evidence or grand jury information. There is nothing improper about it. But Trump's team argued that any public comment by the prosecution constituted prejudice against their client and required dismissal of the entire case or at least a 6-month delay. According to CNN, Politico, and NBC News, all with reporters present in the courtroom, Judge Chen convened an extraordinary hearing at 9 a.m. on January 13th. The room was packed. Reporters, legal observers, and even some members of Congress had come to witness what everyone knew would be a pivotal moment. When Trump's lawyers began presenting their motion, the judge interrupted them after barely 90 seconds. Eyewitnesses report that she took off her glasses, looked directly at Trump's lead attorney, Todd Blackburn, and said something that resonated throughout the room. "Counselor, I'm going to save you your time and this court's time. This motion is frivolous. Period." The silence that followed was described as absolute. You could hear the air conditioner humming. No one moved. What happened next was tense and unprecedented in my experience observing court proceedings. Blackburn tried to argue, saying they had a constitutional right to present their concerns about possible misconduct. Judge Chen responded with a precision that can only come from someone who has completely run out of patience with delay tactics. She pointed out that this was the seventh last-minute motion Trump's team had filed in 3 months. All had been denied, all had been appealed, all the appeals had failed. The judge stated, and here I am paraphrasing the court record, according to reports from multiple outlets, that this pattern clearly had nothing to do with justice or with protecting the rights of the accused. It was pure obstruction. It was a deliberate attempt to sabotage the judicial process through the abuse of legitimate procedures, and she asserted that she was not going to allow that to continue. Trump, seated at the defense table, began to show visible signs of agitation. Reporters in the room noted that he clenched his fists, shifted constantly in his chair, and his lawyers passed him notes frantically, presumably telling him to calm down. But at a certain point, according to CBS News, Trump slammed the table hard enough that pens fell and the sound echoed throughout the room. Several potential jurors waiting in the hallway later told reporters they heard the noise. And then came the moment that changed everything. Judge Chen announced that she would issue a written ruling not only denying the motion, but also imposing sanctions on Trump's legal team for abusive litigation. She declared that the pattern of frivolous delays had crossed the line between vigorous advocacy and malicious obstruction of justice. The sanctions included a $50,000 fine against Trump's attorneys, not reimbursable by the client, and a clear warning that future similar tactics would result in personal sanctions against Trump himself, including potential contempt of court. As a conservative who has devoted his life to defending American institutions, I must say this moment represents something profound. This is not political persecution. It is the judicial system functioning exactly as it was designed, imposing limits on someone who has treated the courts as political arenas where he can intimidate, delay, and manipulate without consequences. The 47-page written decision that Judge Chen issued that same afternoon, according to the Washington Post and the New York Times, which obtained full copies, is one of the most devastating judicial documents I have ever seen directed at a former president. She systematically dismantled every argument Trump's team had presented for months. She cited legal precedents, documented the pattern of obstructive behavior, and used language that, although measured and professional, made absolutely clear that she had reached the limit of her patience. The judge wrote, and here I quote verbatim, according to the reports, "This court has afforded the defendant every procedural consideration the law permits and more. Yet the defendant has responded to each judicial courtesy with new attempts to manipulate the trial calendar. This pattern cannot continue without undermining the fundamental integrity of the judicial process." She continued, "The motions filed by the defense over the past 3 months do not represent good faith efforts to protect the defendant's rights. They represent a calculated abuse of legitimate procedures designed to delay indefinitely a trial the defendant clearly wishes to avoid. That language is extraordinary coming from a federal judge. It is the judicial way of saying, I see what you are doing, and I am not going to tolerate it any longer. But here is the part that should resonate with all Americans, regardless of political affiliation. Judge Chen is a Republican. She was nominated by a Republican president. She has a conservative record in constitutional interpretation. She is not a liberal activist with an axe to grind. She is a respected jurist who came to the conclusion, based on evidence and behavior observed over months, that Trump was abusing the system. Now, this is not the first time in American history we have seen someone try to use endless delay tactics to avoid accountability, but the scale and brazenness here are remarkable. Consider the case of Richard Nixon during Watergate. Nixon also tried to delay, to use executive privilege, and to resist court orders. But even Nixon, when the Supreme Court unanimously ordered him to hand over the tapes, eventually complied. He understood that directly defying the Supreme Court would mean the end of any legitimacy he had left. Or think about the case of Bill Clinton during his impeachment and subsequent civil cases. Clinton also used every legal maneuver available, appealed adverse decisions, and sought delays where he could. But when judges issued final orders, he complied. He testified under oath, even though he lied and faced consequences for it. But he did not simply try to ignore or sabotage the judicial process indefinitely. The difference with Trump is that he has turned procedural abuse into an art form. For decades in his business life, before politics was on his radar, Trump was notorious for litigating this way. He would hire contractors to work on his properties, then refuse to pay the full price. When they sued, his army of lawyers would bury them in motions, appeals, and endless proceedings until the small business ran out of money and accepted pennies on the dollar or simply gave up. That strategy worked in civil litigation against small contractors who could not afford years of legal battles. But now Trump is discovering that public prosecutors do not run out of resources, federal judges do not get tired of enforcing the law, and eventually, as we are witnessing, the system says, enough. The pattern is clear and disturbing. Trump has consistently shown that he sees legal institutions not as neutral arbiters of justice, but as obstacles to be manipulated, intimidated, or ignored. When he was president, he tried to use executive power to interfere with investigations. He fired the FBI director, ordered subordinates to defy congressional subpoenas, and when he left office, he continued the same behavior, only now without the protections the presidency provides. Judge Chen, in her ruling, did something I consider crucial for the future of the rule of law in the United States. She meticulously documented every instance of obstructive behavior. She created a record that appellate courts will be able to review and that will set a precedent for future cases. She essentially said, when a defendant, no matter who he is, systematically abuses the judicial process, judges not only have the right, but the duty to impose consequences. So what does this mean for the trial that will now proceed as scheduled? Let me explain the implications precisely. First, Trump can no longer delay. The judge made absolutely clear that she will not entertain more motions designed to postpone the start. The trial begins January 15th, period. Any further attempt to interfere will result in immediate and potentially more severe sanctions. Second, Trump's credibility before this particular jury has been damaged before the trial has even begun. The potential jurors, many of whom were in the courthouse building when Trump had his outburst and slammed the table, now have an impression of someone who loses control when he does not get his way. That is not the first impression you want to give the people who will decide your fate. Third, the judge's decision imposing sanctions sends a signal to other judges in the multiple cases Trump faces in various jurisdictions. It shows that it is possible and appropriate to impose consequences when Trump abuses the process. That may stiffen the spine of other judges who have been patient but increasingly frustrated. The political implications are also significant. Trump now faces an impossible choice in how to handle this publicly. On the one hand, his base expects him to defy, to call the judge corrupt, to claim political persecution, and never, under any circumstances, to show submission to judicial authority. That is a central part of his brand. On the other hand, continuing to attack Judge Chen while the trial is underway could result in additional sanctions, including potential contempt, which could mean jail time. And if Trump escalates his attacks and the judge responds with harsher sanctions, that validates the narrative that Trump truly does not respect the rule of law. Here is the fundamental problem Trump faces. For decades, he was able to intimidate opponents because he had more money, more lawyers, and more willingness to fight dirty than most people. But a federal judge with a lifetime appointment cannot be intimidated that way. They cannot be fired. They cannot be bought. And when they finally decide to impose consequences, they have the full power of the judicial system behind them. According to reports from Politico and CNN, the reaction inside the MAGA world has been predictably divided. Trump's most loyal allies immediately came out to attack Judge Chen, calling her an activist, accusing her of political bias, and demanding her recusal. Steve Bannon, on his podcast, called the ruling a declaration of war by the deep state against the MAGA movement. But here is what is revealing. Even some prominent Republicans who generally defend Trump have remained silent on this incident. When several Republican senators were asked about the judge's decision and Trump's reaction, according to The Hill, they simply refused to comment. That is political language for, we don't want to defend this, but we also can't criticize Trump without enraging our base. The silence of figures who would normally rush to defend Trump speaks volumes about how indefensible this behavior really is. The decision and the imposition of sanctions represent a defining moment. Andrew Weissman, former federal prosecutor and veteran of high-profile investigations, went on MSNBC and stated, "This is exactly what the judicial system must do when faced with blatant procedural abuse.